There is an entire industry of lawyers and financial advisors running around telling people to put everything they own into a living trust. And most of it is good advice. I have said many times that estate planning is one of the few areas where spending money on lawyers actually makes sense. Unlike most legal work, which is just sophisticated wealth transfer from clients to attorneys. But here is what nobody talks about: what you should not put into your living trust. This is the information gap that has cost people I know hundreds of thousands of dollars, not because they did not have a trust, but because they stuffed the wrong things into it like a child, cramming everything into a closet before their parents come home. If you will allow me, I would like to present the case of Pete Moneywise. Pete is a married, 78-year-old father of 3 who wants to get his financial affairs in order before his passing. Now, Pete is a hypothetical character I created for this discussion, but his situation reflects what countless people of retirement age face as they draft their wills and create their trusts. Pete represents every person watching this video who is thinking about estate planning. When I asked Pete why he was so interested in living trusts, he told me something that stuck with me. "I hate probate," Pete said. "I went through it when my father died, and my family spent the next year talking to lawyers, trying to get things squared away." He shared how the probate process caused tension between his siblings, arguments over who gets what, lawyers sending bills every month, family dinners that turned into shouting matches. But what frustrated Pete most was one unanswerable question. Why didn't Dad create a living trust? It would have made things so much simpler. Credit Pete for now, following his own advice. He has set up a living trust. Now, he must decide what, if anything, to leave out of it. So today, I am going to tell you about 5 specific assets that should never go into your living trust. Pete has done the homework for you, and I am going to explain exactly why, because understanding the why is always more important than memorizing the what. Before we dive into what to keep out of your trust, let me explain why Pete, and frankly anyone with sense, hates probate so much. Unfortunately, many folks do not even know what probate means until they are in the thick of it. And by then, it is too late. When a person dies, even if they left a will, a legal process called probate often ensues. Probate is required to validate the will, name an executor to administer the estate if there is not one, pay off liabilities, and then distribute the remaining assets to heirs. The process can take years. Years! It requires piles of paperwork and ongoing legal fees. Lawyers love probate. It is a reliable source of income that keeps on giving, month after month, while grieving families wait. Let me give you a real example. When Ozzy Osbourne passed away, reports began surfacing that his $220 million estate would face hefty inheritance taxes and a lengthy probate process. According to estate planning attorney Gideon Alper, if Ozzy's assets were left in trust, his family could inherit faster and privately. $220 million. And even at that level, probate creates problems. Imagine what it does to normal families like Pete's. In Pete's case, a trust could have helped his family avoid probate, protect their privacy, and minimize estate taxes when his father died. A trust is simply a document that allows you to keep control of your money and property and designate who receives it once you die. That is why Pete created one, and that is why you should too. When it comes to funding a living trust, most people have this preconceived notion that they must put absolutely everything into it. Every asset, every account, every piece of property, as if the trust were some kind of magical container that makes probate disappear. Well, it is not magic. It is just legal structure. And like any structure, it works better when you use it correctly. There are specific assets that you definitely do not want to place into your living trust. Why? Because it can cause negative tax ramifications. Or worse, it could bring liability directly to you and everything else in that trust. Pete learned this the hard way. When he first set up his trust, his attorney told him to put everything in. Everything. So Pete, being a diligent man, started transferring every asset he owned until I stopped him. And I have always said the best way to get rich is to avoid being stupid. The same applies to estate planning. The best way to preserve wealth for your heirs is to avoid making stupid mistakes with your trust. Let me walk you through the 5 assets that should stay outside. These are the 5 things Pete needed to hear, and probably the 5 things you need to hear too. The first asset you should not place into your living trust is vehicles. And I mean cars, trucks, boats, motorcycles, recreational vehicles, anything with a title that moves. Pete owns a 1967 Ford Mustang that he has restored over 20 years. Beautiful car. He wanted to put it in his trust so his son would inherit it smoothly. I told him that was a mistake. Here is why. Now, someone once asked me if they should put their mule into their trust. I told them if they are still using a mule for transportation, they have bigger problems than estate planning. But seriously, there are 3 specific reasons why vehicles should stay out of your living trust. Whether it is a 1963 Corvette, a Harley Chopper, a prop plane, or Pete's beloved Mustang, the same rules apply. Reason 1, you do not need to. The whole point of a living trust is to bypass probate, but vehicles already bypass probate easily. When you pass away, all your successor trustee needs is a copy of your death certificate to transfer that vehicle to whoever you want to receive it. All that is required to pass on a vehicle is a simple written instruction to transfer the title to a beneficiary. That is it. You just write in your final instructions that you want your truck to go to your son. Your trustee sees that, contacts the DMV, shows the death certificate, and transfers the title. Simple. No probate. No trust required. I told Pete, just write in your instructions that the Mustang goes to your son. Done. No need to complicate it. I have always believed in not doing unnecessary work. And putting vehicles in a trust is unnecessary work that creates unnecessary problems. Reason 2, lawsuit exposure. This is the reason that really matters. When you retitle your vehicle into the name of your living trust, you are basically hanging a sign that says, hey, I have a trust full of assets, please sue me. If a vehicle is held in a trust, you could be vulnerable to lawsuits over accidents involving that vehicle. And not just the vehicle. Everything in the trust becomes a target. Let us say there is a car accident. Maybe your grandson was driving your car and he hit someone. If that vehicle is titled in your trust name, I can guarantee you that the plaintiff attorney will name your trust as a defendant in the lawsuit. Pete has 3 grandchildren, teenagers. They borrow his cars all the time. I asked him, do you want your entire estate exposed because your 17-year-old grandson rear-ended someone at a stoplight? He went pale. He had not thought about that. Now suddenly, every asset in that trust is potentially exposed. Your house, your investments, your savings, all because you put a $40,000 car into the same trust as your $2 million estate. That is what I call an unforced error. A mistake that was entirely optional, entirely avoidable. Keep your vehicles in your own name. Keep your trust out of vehicle-related lawsuits. Reason 3, insurance confusion. The third reason is more practical. Insurance companies get confused when you try to insure a vehicle that is titled in a trust name. I have watched insurance agents stare at their computer screens for 20 minutes trying to figure out how to process this. These are the same people who are supposed to pay your claim when something goes wrong. Do you really want them confused about who owns what? Warren always says, never ask a barber if you need a haircut. I say, never give an insurance company a reason to deny your claim. Keep your vehicles simple. Keep them in your personal name. Now, there is one exception. If you need anonymity because you have had problems with people in the past, stalkers, crazy ex-spouses, business enemies, then putting a vehicle in a trust might make sense for privacy reasons. But understand the trade-offs. You will have to shop around for insurance. You will be exposing your trust to potential liability. Make sure the privacy benefit is worth the cost. Pete does not have stalkers or crazy ex-spouses, so his Mustang stays out of the trust. Problem solved. The next three assets are all related, so I am going to discuss them together. IRAs, 401. Annuities. Pete has all three. A traditional IRA with $400,000. A 401 from his old company with $200,000. And an annuity worth about $150,000. He was about to transfer ownership of all of them to his living trust. I nearly fell out of my chair. These are retirement accounts that have special tax treatment. And here is what most people do not understand. These accounts are already trust-like structures themselves. They have their own rules, their own beneficiary designations, their own tax advantages. A trust can turn non-taxed accounts into taxable ones. Read that again. A trust can turn non-taxed accounts into taxable ones. When you try to take these assets and change ownership to your living trust, you are not being clever. You are being stupid. And stupidity in tax matters is very expensive. If you transfer ownership of your IRA or 401 to your living trust, the IRS considers that a complete distribution, a liquidation, a taxable event. Let me translate that into plain English. If you have $600,000 in your IRA and you put it into your trust, the IRS will treat that as if you withdrew $600,000. You will owe income tax on the entire amount in 1 year. Pete's $750,000 in retirement accounts. If he had transferred ownership to his trust, he would have owed approximately $250,000 in taxes immediately in 1 year at age 78. That would have destroyed a third of his retirement savings. Gone, poof, because he did not understand the rules. I have seen people accidentally create tax bills of $200,000 because they thought they were being smart with estate planning. They were not being smart. They were being catastrophically ignorant. The special tax-deferred nature of these accounts is their entire value. When you try to put them in a trust, you destroy that value. It is like buying a Rembrandt and immediately setting it on fire to see if it is flammable. Yes, technically you learn something, but at what cost? What you should do instead is name your trust as the beneficiary of these accounts, not the owner, the beneficiary. However, you can make the trust itself the beneficiary so that these accounts pass directly to your trustees without an IRS agent crashing the wake. This way, when you pass away, the assets flow into your trust and get distributed according to your estate plan. You get the control you want without triggering any immediate tax consequences. That is what Pete did. His wife is the primary beneficiary. His trust is the contingent beneficiary. If both he and his wife pass, the money flows into the trust and gets distributed to his 3 children according to his plan. Now, let me tell you about a huge mistake I see constantly. When people open retirement accounts, they are asked to designate a beneficiary. Most people list their spouse as the primary beneficiary, which is fine. Then there is a line for a contingent beneficiary if your spouse is no longer living. And here is where people make the mistake. They think, well, I want it to go to my kids. So they write their children's names as contingent beneficiaries. But wait, in their estate plan, they specified that their children should not receive assets until age 45. Maybe they have good reasons for that. Maybe the kids are irresponsible. Maybe they are in bad marriages. Maybe they are 23 and 24 years old and have no business controlling $600,000. But if both parents die in a car accident, guess what? Those IRA and 401 assets pass directly to the children outside the estate plan. The kids get everything immediately, regardless of what the trust says. Pete's youngest son is 32. Good kid, but terrible with money. Pete's trust says he should not receive his full inheritance until age 40. But if Pete had listed his son directly as contingent beneficiary on his IRA, his son would get $200,000 immediately if both Pete and his wife passed. Pete knows his son. That money would be gone in 18 months. New truck, bad investments. A girlfriend who suddenly gets very interested in marriage. I have watched families destroyed by this mistake. A 23-year-old inheriting $600,000 with no restrictions is a recipe for disaster. New cars, bad investments, worse boyfriends. The money disappears faster than you can say I should have named the trust as beneficiary. Name your trust as the contingent beneficiary. Give your trustee control. Protect your children from their own worst impulses. The fifth asset that should not go into your living trust is life insurance. Pete has a $500,000 life insurance policy. He wanted to put it in his trust for the same reason he wanted to put everything else in there. Control, certainty, avoiding probate. I told him he was solving a problem that does not exist. Like retirement accounts, life insurance has its own beneficiary designation. It already bypasses probate. So putting it into your living trust is solving a problem that does not exist. You do not need to put life insurance in a revocable trust. Rather, you can simply name your beneficiaries within the policy. The simple approach is to name your spouse as primary beneficiary and your trust as contingent beneficiary. If your spouse is living, they get the proceeds directly. If not, the money flows into your trust and gets distributed according to your plan. And unlike the waiting time you might expect through probate, life insurance is typically paid out within weeks or months, not years. That means your children get support sooner rather than later. Now, here is where things get interesting for those with larger estates. If you live in a state with a low estate tax exemption, say $2 million, and you have a $2 million estate plus a $2 million life insurance policy, you might have an estate tax problem. Life insurance proceeds count as part of your estate for tax purposes. That $4 million total could trigger significant estate taxes. In this case, you might want to create an irrevocable life insurance trust called an ILIT to avoid estate taxes. Not your living trust, a separate irrevocable trust specifically designed to hold life insurance outside your estate. Pete's total estate, including his life insurance, is under the federal exemption, so he does not need an ILIT. But if your estate is larger, this is worth discussing with an estate attorney. This is one of those areas where spending money on a good estate planning attorney actually pays for itself many times over. The tax savings can be enormous. While we are at it, let me share 2 more things Pete discovered in his research. Checking and savings accounts. If you use checking and savings accounts to pay monthly bills, you may run into financial complications if you put them in your trust, unless you are the trustee and granted full control of trust assets. There is a much easier route to take. Keep these accounts out of the trust. Use them for daily expenses. Keep your trust for the big assets held in other countries. This gets complicated. You may not be permitted to place international assets in a trust. Different countries have different rules about trusts, and some do not recognize them at all. To find out if it is possible, you will need to consult an estate attorney licensed in the country where your assets are located. Do not assume American rules apply everywhere. So let me summarize what we have covered. Here are 5 things to consider as you structure your living trust. 5 things Pete needed to hear, and 5 things you need to hear too. 1, vehicles. They do not need to be there. They expose you to lawsuits, and they confuse insurance companies. 2, 3, and 4, IRAs, 401s, and annuities. Putting them in your trust triggers immediate taxation and destroys their tax advantage status. Name your trust as beneficiary instead. 5, life insurance. It already bypasses probate. Name your trust as contingent beneficiary Or consider an irrevocable life insurance trust if you have estate tax concerns. Everything else, put it in your trust. Real estate, bank accounts, brokerage accounts, business interests, those belong in your living trust to avoid probate. Clearly, even wealthy individuals like Ozzy Osbourne can get it wrong. That is why it is important that you meet with a qualified and regulated financial professional to make sure you are not making mistakes with your estate planning. I have always said that hiring the right experts is one of the best investments you can make. A good estate planning attorney will pay for themselves many times over in taxes saved and disasters avoided. Pete met with a certified financial planner and an estate attorney. It cost him a few $1,000s, but it saved him from a $250,000 tax mistake with his retirement accounts. That is what I call a good return on investment. I have always said that the best thing a human being can do is help another human being know more. Estate planning is not glamorous. It will not make you rich, but it will protect what you have built for the people you love. And that is worth more than most things people spend their time worrying about. The wealthy do not have better trust because they have more money. They have better trust because they pay attention to details that most people ignore. They ask questions like, what should not go in here? Instead of just throwing everything in and hoping for the best. If Pete were real, he would surely remind you that the information in this video does not constitute legal advice. Talk to a trust lawyer in your state, a financial advisor, or other professional before making any decisions. Avoid the mistakes I have described today. Get your beneficiary designations right. And remember that in estate planning, as in investing, the big money is made by avoiding big mistakes. Pete's imaginary kids, and your real ones, will be grateful you did. Your heirs will thank you, even if they never know what disasters you prevented.